This webinar is meant for OCASI member agencies to support frontline workers in their work with refugees, migrants, and people with precarious immigration status. We want to thank Chinese and Southeast Asian Legal Clinic for putting this webinar together so quickly. I'd like to quickly introduce our two presenters today. Avvy Go is the clinic director, and Chien is the staff lawyer at the Chinese and Southeast Asian Legal Clinic. Thank you both. And now, over to you, Chien.
Hi, this is Jen. Sorry about that. I was just having some difficulties unmuting. So quickly, by way of background, a little bit about our clinic. Our clinic is based in Toronto, and we are a specialty community legal clinic, meaning that we serve specific clientele and we do so province-wide. And we provide pro bono free legal services to those who are low income and have language barriers and are members of the following communities, and that's Chinese, Vietnamese, Laotian, and Cambodian. For Chinese, we speak both Mandarin and Cantonese. And the clinic is on nonprofit, although we are funded by Legal Aid Ontario, we are independent from the government. And if you want more information about the practice areas and some helpful brochures, as well as up-to-date information about COVID-19 supports that are going to be discussed in this presentation, you can visit our website there. So this presentation will be split into two sections. I will cover the new CERB and EI, as well as briefly the Ontario Emergency Assistance. And our clinic director, Avvy Go, will cover Ontario Works, CCB, as well as other benefits. So first off, we're not going to go into great detail about EI or the regular benefits, sickness benefits, because as frontline workers, as agency workers, we know that you're very familiar, but we'll just go through them very briefly. First of all, for regular benefits, as we know, it's for individuals who've lost part or all of their income, and they can apply within 4 weeks. In fact, they're encouraged to apply within 4 weeks, or else potentially benefits may not be coming their way. And depending on the number of hours, insurable hours they've worked in the past 52 weeks, and depending on where they live and the unemployment rate in that region where they live, the eligibility differs. And the chart is available on the canada.ca website for more details. And the amount of benefits up to a maximum of $573 per week is 55% of the worker's average insurable earnings. So this remains unchanged as a result of COVID-19 pandemic response from the federal government. The worker would still need to meet the number of hours, again, according to the grid that you can find online. The same eligibility requirements are, namely, they have to have not lost a job as a result of something they've done. So for example, they could not have been fired for cause or something that they've done, for example, as a result of being disciplined. They need to have been without work for at least 7 consecutive days within the last 52 weeks. And they need to have worked the number of required hours, again, according to that chart. And that's within the last 52 weeks or since their last claim, whichever one is shorter. And as we all know, the worker needs to continuously every 2 weeks report to Service Canada they're still willing and able to work and they're actively looking for work. And sickness benefits is similar. They still need to meet the eligibility requirements in terms of the number of hours, which here it's 600, and that's a flat number of hours, in the past 52 weeks, and again, or since the last claim, whichever is shorter. And in terms of the reasons for applying for EI sickness, they need to be able to prove that they're ill, that they were injured, or they're in quarantine. Now, these rules will, there will be exception to these rules. I'll talk about that a little bit later in the presentation. And similar to regular EI, a successful claimant would receive 55% of their earnings up to a maximum of $573 a week. So what is the COVID-related government response, and how does it change the EI regime? Well, on March the 13th, the government of Canada announced that the 1 week waiting period for claimants, only those under quarantine, is waived. So normally for EIs, as many of us know, there is a 1 week wait period, and they treat this almost as if it's a deductible under a regular insurance scheme. So that means if the claimant is successful under normal circumstances outside of the COVID response, there would be a 1 week period in which they would not receive any benefits at all. Now, under the changes announced a couple weeks ago, that 1 week waiver is eliminated, or rather the 1 week wait period is eliminated for the purposes of quarantine only. And this is not automatic. The claimant would have to call the number that's on the screen. And last we checked, the number is very much backlogged, so we do expect anyone calling to be on hold for quite a while. And the number is only for those who've already applied, whether that's online or whether that's by phone. And the second announcement in response to COVID-19 is that unlike before, there's no need for doctor's notes. No more medical certificates are needed in the context of applying for EI sickness if it's COVID related. And lastly, which is a new change, a new action by the government of Canada, is that for those who don't or cannot, because they're in quarantine, have access, let's say, to a computer, or they're too sick to call, they can apply later and have those claims backdated. So the focus of the presentation essentially is this new benefit that's been announced. It's called the Canada Emergency Response Benefit, and for ease, I'm just going to call it CERB moving forward. And the CERB was announced very recently on the 25th. It's essentially a amalgamation of two benefits that were announced the week prior, which was the emergency support benefit and the emergency care benefit. And the federal government basically said, this is just streamlines it, makes it easier. We don't need to differentiate between those who are providing support and those who have lost their income as a result of COVID-19. We'll just make it one comprehensive benefit. And as was previously announced, what successful claimants will receive is $2,000 a month for up to 16 weeks. And that equals about $500 a week. And the benefit period, the maximum benefit period is indeed 16 weeks, but it's broken down into 4-week segments. And so for the initial segment, they would essentially have to make the application, they need to prove certain criteria, and then moving forward, it's simply just an affirmation or attestation confirming that the situation has not changed, that they're still unemployed as a result of COVID-19, or they are still employed, but they're not receiving any income. And this benefit is backdated to March 15th and will be available until October 3rd. For anyone who is applying, they can do no later than December 2nd. But as you'll see later on, most people would apply well before that date. So there's quite a lot of eligibility. So we've divided it into different types of eligibility. So I'm going to talk about the different reasons why somebody would apply for this for CERB and would be approved. So this would be, as previously mentioned, only for those workers who've lost employment income as a result of COVID-19, not because of market conditions or any other reasons. So we looked at people who lost their jobs, those who are still employed. So that could be somebody who's furloughed by their workplace, that they're still technically on the payroll, they're still technically employed, but they're essentially given an absence from work because of the situation. So whether it be a restaurant worker because the restaurant is closed, or whether it's a nail salon worker because, again, their workplace is closed. And those who are sick, of course, with COVID-19 are eligible for CERB if they are not eligible, for example, for EI sickness. Those who are in quarantine. And for these two categories, similar to the exception I just talked about in the context of EI sickness, there is no need for a doctor's note. Next, we have people who are caring for those who are quarantined and who have COVID-19. And lastly, parents who have to stay home because childcare is not available. So schools closure or daycare closure, they have to stay home. Those individuals are also eligible. And CERB is a special sort of, emergency response. It's only for a short period of time. It's for 16 weeks. And so it's for everybody, regardless of whether or not they qualify for EI. And a little bit later, I'll talk about the relationship between EI and CERB. And what's very important is that for at least the first category, those who've lost their jobs, they cannot lost their jobs as a result of quitting or something they've done voluntarily. So similar to the criteria for EI regular benefits, you can't have just walked off the job. Of course, there's going to be exceptions. So for example, we talk about it a little bit later if there's questions, but there are exceptions in terms of someone who feels that their workplace is unsafe. Though that's an exception for someone who leaves, and that will not be counted if they go through the regular steps of the provincial health and safety statute and regulations. That would not be considered as quitting voluntarily. So next part in eligibility, and again, quite a lot of eligibility requirements. Next is what type of worker. So essentially everybody. You can be a regular wage earner and have a salary. You can be a contract worker and freelance. You can also be self-employed. In terms of immigration status, unfortunately, for those who work in this helping immigrants and refugees, it is rather limited. That is, of course, you have to be legally eligible to work in Canada. And that includes, in addition to citizens and permanent residents, temporary residents who are permitted to work. So an example would be a temporary foreign worker who has a valid work permit, as in it has not expired. Or it could be an international student with a study permit that says very clearly on their study permit that they can work either on campus or off campus, or both. In terms of financial eligibility, the rules say that the claimant has to have earned at least $5,000 either in the calendar year of 2019 or in the immediate preceding 12 months before they apply. And it could be from various sources. So the regular sources would be employment, including self-employment. It could be they receive EI benefits for the maternity leave or parental leave, or, and this is only, as far as I know, in the context of Quebec, but if they receive similar benefits through a provincial plan for maternity and parental leave. And while the $5,000 does not need to be earned in Canada, it does need to be earned in terms of, it needs to be insurable earnings, meaning under normal circumstances, and again, there will be exceptions, the income has to be where the employer is paying into an EI scheme for the employee, and that needs to be at least $5,000. In terms of further financial requirement, while they are, essentially, how long do they need to be out of work? And that is essentially 14 days in a 4-week period. If you think of the 4-week period as a box, it could be the 2 weeks could be the front, the middle, or the end. However, for normal circumstances, for those who have been out of work and not been receiving employment income for quite some time, we recommend that they apply as soon as possible because the 4-week period is coming up in the middle of April. And the employment period is, again, the initial 4-week period, and then it's 4 weeks from when they are approved. So again, they need to be without income. So if they're receiving EI, whether it's regular sickness or parental or pregnancy leave, that would be excluded. That would be considered employment income. If through their workplace, there's a, for example, paid sickness benefit, paid leave, and they're sick with COVID-19, that would also be considered ineligible. And as well, if somebody is currently on parental or maternity leave, whether through EI or through their provincial scheme, that would also be considered employment income, and thus they would not be eligible for CERB. Further eligibility requirements, pretty straightforward and simple. The person needs to be at least over 15 years of age. They need to be physically residing in Canada. So for example, someone who, even if they're working for a Canadian company or even the Canadian government and living abroad, they would not be eligible for CERB. And they would have to have a social insurance number. Now, the application process has been clarified yesterday. Before that, we were just hearing that it would be sometime the week of April the sick. Now we know that it will be open, the online portal will be open on April the 6th, which is Monday. This whole process will go through CRA, and they can apply in several ways. They can apply online. There will be a dedicated web page, canada.ca, and the rest is forthcoming. But essentially, if they have a CRA account, or if they have an account through Service Canada, they can actually convert that into a CRA account if they haven't done so already. And then for those who don't have access to technology, there is a toll-free number, and that number has not yet been released. For the sake of efficiency, we do recommend to any clients that if they have access to the internet and they're able to do so, that they register for a CRA My account before the 6th, just so that they're ready to go when the portal opens. So this part is a bit odd on first glance, but essentially what the government of Canada has done is recommend days of the week that's best for applicants based on the month they were born. So for the first 4 days, Monday to Thursday, you just have to look at what month you were born, and then it corresponds to the best day to apply. On the weekends and Fridays, it's sort of a free-for-all. It doesn't matter what day what month you were born. As far as I'm aware, and this is just announced yesterday, so there's still some questions. This isn't mandatory. I think it's suggested. So and I imagine this would be the case, people are eager to apply, and let's say their birthday is not in January, February, or March. I don't think the system would bar you from applying on day 1 on April 6th, but this is sort of the best practice. Well, in terms of payments, similar to what I was saying about application, there's an efficient way and there's a less efficient way. So obviously, with snail mail, you're going to get your check in the mail if you're eligible. And from the time you apply, assuming that all the supporting documents are completed and assuming there's no errors in the application, it would be 10 days. And it's much faster. You cut that down by a week if the applicant opts for direct deposit. And so we know that not every claimant will have that possibility, but to the best of their ability, if there's a bank account, they should either tell the CRA officer on the phone, or they need to input that information through the online portal. And the benefit is tax deductible, but it will not be taken at the source, meaning that unlike when you receive a paycheck and you have income tax and EI, CPP, all that deducted automatically, this will be done at the end of the year, actually next year, when you file your 2020 income taxes. Now, here's the part where it gets a little bit confusing if you're not already confused, and that is the interaction between CERB and EI. And the main question, and this criteria was only announced yesterday. Prior to yesterday, there was different criteria, which I'll not get into as to not confuse you. But essentially, the main question to be asked in terms of determining whether or not the claimant, if they're eligible for EI, whether they get the CERB first or the EI first, is when did the claimant become eligible to receive EI benefits? The information we received is still not too clear, but as we know, with the exception of EI sickness benefits in the context of quarantine due to COVID-19, in all other cases, there is a 1-week waiting period, meaning that if the claimant is successful, they would still have to wait a week between the day that they no longer have income to when the benefits are starting to be paid out. My personal interpretation, it's not really backed up by much. Again, we only received all this information from the Government of Canada yesterday, but my sort of interpretation of the plain language of what's on the Government of Canada website, as well as what was discussed during the various press conferences, both with the Minister and the Prime Minister, is that it's when you receive the benefit, not when you become, not when essentially you're approved. So what does that mean? Well, I'll give you some examples through scenarios so that we have some sort of concrete examples to have a better understanding. So the first scenario is the worker is eligible to receive EI benefits before March 15th. So this is pretty clear if you are eligible to receive EI benefits before March the 15th. My interpretation is that if you are not receiving any payments, let's say you're in the waiting period, let's say your waiting period starts on March 1st, and you don't physically receive money until March 8th, in that case, you would still be covered by EI. Another scenario is if you, let's say, are approved on let's say the 8th of March, but you don't start receiving EI benefits until the 15th of March when your wait period completes, then my interpretation is that you would be eligible for CERB. So in the situation that we just talked about, the first situation where it's very cut and dry, you're not really on the cusp, you've started receiving EI benefits well before March 15th because of COVID, then you're going to basically receive that benefit until your benefit period runs out, until EI benefits that you're specifically given runs out. That could be anywhere between 15 to 45 weeks, depending on the different factors we talked about earlier. If your EI benefits runs out before October 3rd, and that's the second crucial date, and you're still not able to go back to work because of COVID-19, hopefully it's not that long, but if that's the case, the worker can still apply for CERB. So for those who are sort of upset or kicking themselves because they lost their income because of COVID-19, but this happened in the early days. So we know, for example, certain communities, for example, Chinese communities with businesses in Chinatown, we know that those businesses lost income, and some of them were forced to close well before the state of emergency was announced by the provincial government, and well before the shutdown of all but essential services. So for those cases, they can still apply for CERB once their EI runs out. But in many cases, especially for those with low income, we know that the EI benefits will be a lot lower than the $500 a week under CERB. So that's unfortunate. And in these cases, if they've not already done so, where they're eligible to receive benefits before the 15th, they should apply as soon as possible, because as I said earlier, the EI application should be done within 4 weeks of when the person loses their income. So scenario 2 is, let's say the worker is eligible to receive benefits afterwards, after March 15th, after this key date. And they have 2 options. Really, they only have about 4 more days for option A, but what they can do is they can apply for EI now through the EI portal as usual. Once their application is being processed by CRA, they're going to be sort of redirected to the CERB stream within the CRA. And they're going to receive that 16 weeks of CERB at $2,000 a month. And after the CERB runs out, then they're automatically, because they've already applied through EI through the EI portal, they're going to be automatically transferred back to the EI stream without having to apply, or reapply, I should say. So they would get the CERB amount for 16 weeks, and if it's still needed, if they're still unable to return to work, then they will receive 55% of their regular earnings through the EI stream. If they choose to wait until March 6th or after March 6th and just forego the EI portal altogether, they can do so. They're going to have the exact same results, which is they're going to receive 16 weeks of CERB. But the only difference is that once the CERB runs out, they have to actively apply for the EI benefits through the EI portal, because they only went through the CERB portal. So that does sound a bit confusing, but essentially same results, with the exception of the fact that option A gives you the benefit of not having to apply twice. Third scenario is what happens if a worker doesn't qualify for EI at all, but they do qualify for CERB. This one's pretty straightforward, because CERB is for both those workers who are eligible for EI and those who don't qualify. Essentially, they would just on or after April the 6th apply for CERB through the portal or via telephone. And if they're eligible and successful, they're going to get those 16 weeks of CERB at $500 per week, and that's it. Scenario 4, what happens if in the case we just talked about, where the worker lost their employment income well before March 15th as a result of the pandemic. In that case, unfortunately for CERB, they're only going to get benefits from the 15th onwards because the CERB is only backdated to the 15th of March. And they will receive the 16 weeks per usual, and they should apply as soon as possible because, as we've said, CERB, you're only eligible if you are not working for 2 weeks out of that 4-week box, so to speak. And if they want to have the maximum benefits as soon as possible, they should definitely apply no later than the end of the week of April 6th, which is April the 10th, I believe, is that Friday. This is a little bit switching gears a bit. We're going to talk about the Ontario Emergency Assistance. This is something that is available, it has been available under the Ontario Work Scheme, and it's for those who don't qualify for EI or CERB, so you cannot get both. It's available for a very short period of time, it's only 48 days. So normally, under regular circumstances, with few exceptions, so unless a person is experiencing family violence or refugee claimant in certain circumstances, normally you can only apply once every 6 months. However, the provincial government has indicated that for those who are affected by COVID, they can apply more often. And it's paid out once every 16 days. And there would be 3 periods of 16 days each, bringing the total to a maximum of 48 days. And again, that 6-month requirement, once every 6-month requirement, is waived. The amount of assistance is less clear than CERB and even less clear than EI. It's up to the administrator. So it's up to decision maker at OW to decide what the claimant gets. And the eligibility requirements are much simpler than CERB. And so that is the family or individual has to be low income. They cannot be receiving any other assistance, such as federal assistance or OW or ODSP. They can't be a tourist or a visitor, which means that it's more permissive than either EI or CERB. So they could actually, in this context, be someone with precarious status. And they have to face an an emergency situation where they can't meet the basic needs. And of course, COVID-19 is an emergency situation. That part would be met, but they would need to prove that as a result of COVID-19, the family or the individual can't meet the basic needs of that unit and can't also provide for shelter expenses. So a bit more about eligibility. The administrator, who's the decision maker, needs to be satisfied the applicant has made a reasonable effort. So basically that means that if there are other resources such as EI, such as CERB, that the applicant needs to have looked into it and eliminated those as possibilities. And the applicant also needs to prove that right now in their income or their assets, they don't have enough to meet the family's basic needs and shelter expenses. And very importantly, they need to prove that if the administrator, if OW refuses and denies the assistance, they need to prove one of 2 things: that there is a danger to the physical health of the individual or the family unit, or that there would be essentially removal of at least one dependent child from the care of the parent. So that could be having CAS involved. It's not quite clear, but it would have to be pretty dire consequences. And finally, there's also an online portal. It existed through MCCS, for quite a while, and it's the same application portal as regular OW. So you just go onto the MCCSS website, and there's a very long list of documents that you need to submit as supporting documents, and the administrator can give amounts for basic need, and they may also give for shelter benefits. This is all at the discretion of the administrator. And unfortunately, the decision of the administrator cannot be appealed, unlike other decisions under the Ontario Works Act. And the good news is that because it is an emergency assistance, the provincial government seems to understand that you can't always get this massive laundry list of documents immediately. So what they've done is they do provide the interim assistance for that first 16-day period. Recall that there's 3 16-day periods up to a maximum of 48 days. And so, but after the initial 16-day period, so on day 17, essentially, you need to provide the entire application, which includes, again, a pretty long list of supporting documents and all the requisite paperwork signed. And so thank you. That's my half of the presentation. I'll turn it over to Avvy for the second half, which will be talking about CCB, OW, and other benefits.
Thank you. I'm waiting for the organizer to give me access to show my screen. But in the meantime, I just want to thank you for everyone for joining in the webinar this morning. It's a very strange time that we're all in. Anyway, so I also want to just remind people, if you can, send your questions through the chat box. Instead of the question box, we can't really see the question box. I've seen already a number of questions that were posted, so I'm while I'm waiting. So Amy, I don't have a thing to share my screen, or I'm not sure if I can right now. Oh, okay. So anyway, so. While I'm waiting, I do see some questions. There's some theme. A number of questions ask whether or not people who have some income, so they may have reduced hours of work, whether those individuals can apply for CERB. So based on our understanding, the answer is no. It's people who have no income will be able to apply for CERB. However, in some cases, I know that some companies are for some reason I'm hearing echo. Some companies are reducing the number of hours that the workers are able to work. Then in that case, I would suggest that the employer should be applying for what we call a work share program, and the government has also made some changes to the work share program to make that possible. Amy, can you tell me whether I can share my screen now? Okay, thanks. Okay, thanks. So I am covering a few things, sort of Canada Child Benefits, OW, ODSP, and a couple of other things. But I'm going to go through some of those very quickly because the point of my presentation today is to talk about what happened to the people who are not eligible for EI or CERB because of their immigration status. Would they be able to get some of these benefits? And so I'm going to skip over the Canada Child Benefits very quickly because I'm sure many of you are familiar with CCB. And the slides contain some information, basic information about CCB, and the slides will be available to you after the presentation. One change that is being made as a result of COVID-19 by the federal government is that they will enhance CCB by increasing the maximum annual payment by $300 per child for the 2019-20 benefit year. So that is the one key change that is being made. However, the main concern that we have at the clinic is that, in fact, not everyone is eligible for CCB. Not every child in Canada and not every parent in Canada gets CCB. And the main reason why is because under Section 1226.6 of the Income Tax Act, to be eligible for CCB, you have to have a number of requirements, and most particularly, immigration status is one of the requirements. So to be eligible, the parent, or their spouse must be a Canadian citizen, permanent resident, protected person, or a temporary resident who has lived in Canada for the previous 18 months. So that covers some of the visitor or student, for instance. However, who are being excluded are refugee claimants, people without any immigration status, including, I'm sure many of you have served these individuals, people who have submitted an application for permanent resident on H&C grounds, as well as people who are from countries within a moratorium on removal. So they're here in Canada without status, but they cannot be removed by the government. And it doesn't matter if the children are born in Canada or are Canadian citizens or permanent residents. It's the parents' immigration status that counts. So that to us is a very problematic aspect of the CCP. So what's being done is that we continue at the clinic, we continue to lobby the government to make this change. Even during the COVID-19 crisis, we are in contact with the minister and also some of the MPs to talk about this issue. Certainly, it's an important issue for us. And also, we have just recently submitted a report to the United Nations on Canada's compliance with the Convention on the Rights of the Child. And this eligibility requirement for CCP is one of the issues that we're raising. So, so that's what I want to cover on CCP so that I can focus on the other aspects of the presentation now. So for people who are not eligible for EI, for the CERB, and they have no income, they can't work, there's no job out there, what do? Well, they can apply for the Ontario Work. And so I have included, again, some basic eligibility for the Ontario Work here. And I don't want to go through them right now, so we have more time for questions. You'll get the slides later. My emphasis, again, is on the issue about immigration status, because I've been hearing over and over again from many people working in settlement agencies and community agencies that they believe that only Canadian citizens, permanent residents, refugee claimants, and convention refugees are eligible to receive OW. And in fact, this is the information that is posted on settlement.org. In my humble opinion, this is simply wrong. That's not what the law says. So what the law says is that the law actually does not say who is eligible. It only provides a list of who is not eligible. And who is not eligible includes a visitor, and there's an exception even for that. So a visitor is not eligible unless that visitor has made a refugee claim or has made an application for permanent resident. A tourist is not eligible. And then a person against whom a deportation order has been made, or there's a departure order, exclusion order is also not eligible unless the removal order cannot be enforced for reasons beyond the person's control, or the person has made an H&C application. So what it means, bottom line, even though you have no status, if you have clients who have no status in Canada, they may still be able to apply for OW because they are not a tourist, they're not a visitor, and even if they have a removal order, if they are not able to leave for reasons beyond their control or they have applied for H&C, they will still be eligible for OW. So it's very important for us to remember that, because at this time, when people have absolutely no other opportunities to find work, to maintain gainful employment, OW might be the last resort for many people. So my suggestion to agency staff is to actually help people in that situation to apply for OW. Just make the application first and then try to explain later. And I know that many OW workers have the same misconception about the law as you do. So remind them what the law says. And I have provided a sample letter with this slide that you can use to advocate for your client. If the client's application is still denied, then you should file an internal review. And if that's denied, file an appeal to the Social Benefits Tribunal, ask for interim assistance, and then refer, or even before that, refer the client to a clinic for further help. So I have here a sample letter that you can copy and paste later as you please. I have also included some slides about the ODSP. Again, I don't want to go through them, but the bottom line is the same. The bottom line is that the same eligibility criteria about immigration status for OW is the same for ODSP. But of course, at this time, it might not be like most of the people who lost their job due to COVID-19, chances are not eligible for ODSP because ODSP is provided for people with a disability. And so many of these individuals may not meet the definition of people with disability, and also there are extra requirements that they have to submit medical, sort of information and so on. So ODSP is probably not a realistic option for these individuals. So just very quickly go through some of the other benefits. There's also two other things, among others. One is the GSC and one is the work-share program. GSC, they will start in early May 2020. Those who are eligible will receive about 400 for individuals and 600 for couples, the GST credit. The work-share program, and as I mentioned, is for people who have not completely lost their job, but then the employer has experienced a downturn in the in business, and then so they want to reduce the workforce. So instead of firing people, the employer may have an option of creating this work-share program that will allow the workers to reduce their number of days of work and then at the same time access EI. So those are initiated by the employer. So I would encourage agencies to talk to your clients who are in that situation to approach the employer and ask them to apply for the work-share program. And so I have provided some information about the work-share program in the slide as well. So in the final analysis, I'm trying to encourage all of you to think about assisting people with precarious immigration status. Here's a list of something that you could do apart from applying, helping people to apply for the benefits and advocate on their behalf. I would also suggest your agency to get educated about these issues affecting this individual. Review your own policies and practices to see if there are any artificial barriers in accessing your services by people with precarious status, and develop an organization positioned to advocate for these populations. And join in, there are many different coalitions out there who are working to advance the rights of these individuals. So join in, write letters, sign petitions, talk to your local MPs and also the ministers in charge. And that's my presentation so that we have more time for questions. So I'm going to ask Chien to address questions that are concerning CERB, and then I will answer any questions about the interview.
Great, thank you. So I'm just looking through the chat box, and if you have questions and we've missed them, please put them in the chat box if you were in the question section earlier, as Avvy said. So the first question that I see is, let's see, client can let go of the job but cannot quit. Can you explain a little bit more about that? Okay, so essentially this part is a little bit vague. I should also say that because some of the criteria for CERB that was announced yesterday was announced so recently, we're still waiting for the House of Commons to convene. So last week, the Bill C-13 was passed and received royal assent on the 25th of March. That Section 2 of that bill gives you details about the CERB that was essentially announced back when it was still 2 different benefits. So in terms of details, sometimes we just have to say we don't know because we haven't seen the updated act, the updated statute, and even in the old statute, they were going to clarify and spell out the details in regulations. So regulations basically clarify the minute details of what was broadly stated in the statute. And so we don't know a lot of things, but we do know in terms of the fact that you can't quit. It's similar to EI as criteria under CERB. So if you decide that you just simply don't want to do this job and you'd rather stay home, even though you're not taking care of anyone, even though you're not sick, you're not in quarantine, you don't have children you have to take care of, then that would not be considered, you would not be considered eligible because you voluntarily quit. Now, there are certainly circumstances, let's say you work at a grocery store and the employer has made absolutely no changes to protect you. There's been no safety gear, no PPE, no distancing, no setting a certain quota for who can be in the store. Then you can certainly make a complaint under the provincial Ontario Health and Safety system, which would be first a complaint to your employer, and then if your employer still doesn't do anything, then you can escalate that to the government, which will undertake an investigation. Now, I don't have expertise in this area of workers' health and safety, but you can also visit the Ontario Health and Safety Clinic. They have, I think they have an updated 2-pager on what you can do in the circumstance. But let's say it goes all the way up to the investigation and the provincial investigator decides that indeed this was a breach of safety statute under the province, and then you decide to leave that job. Well, then that would be considered essentially involuntary because your employer has made an unsafe workplace, and you would be able to apply for CERB. But you can't simply walk off the job. And as you may recall last week, Premier Ford simply alluded to something along that lines, and there was a deluge of responses from employment lawyers saying, actually, no, it's not that simple. So that's as far as I can respond on that question. Let's see. To apply for CERB, I need to prove I earned $5,000 in 2019 or past 52 weeks. Do you know if CRA is going to ask to have 2019 taxes filed in order to confirm the earnings and to process CERB applications? So I don't think that would be the case because CRA is already delaying the deadline for the 2019 filing until, I believe, August. So that's not the case. But my understanding is similar to EI, you would have to have some of these documents prepared, but it may not be asked for. So the approach in any of these emergency responses, whether it's the payroll subsidy, whether it's the CERB, is they're really just trying to help and process as many applicants as they can. And there may be audits down the road. So we're certainly not telling people who absolutely do not meet the criteria to apply and then to receive money that could potentially down the road give you problems. But we do think that if there's a gray area, then they should apply. And if there's a clawback down the road, then that may very well be the case. So right now, we do know that it's insurable earnings, which means, again, that it would be the normal circumstance where your premiums would be deducted at the source, et cetera, but there are always exceptions. So if there is a question about whether a worker is, let's say they're earning cash, and there's questions about whether or not they meet the definition of that $5,000 of insurable earnings, I would recommend that you have that particular client call a legal clinic because there's not a one blanket statement. It would be a pretty long process. It would involve, if they do get audited, it would involve having to make representations, written submissions to CRA, but that's not to say that it's impossible. So I certainly would suggest that if the client was sort of in this gray area and they may not necessarily have $5,000 of insurable earnings under the strict definition of that term, they could still apply. And if need be, there could be legal steps taken thereafter. Does an individual currently receiving CERB have to notify the government if they return to work before October 3rd? Yes. So the CERB is in 4-week periods, and there'll be 4 periods, and that equals 16 weeks in total. And at the end of every period, 4-week period, they will be asked, just like they do in EI every 2 weeks, but less frequent, they'll be asked to attest as to whether or not the circumstances are still the same. And of course, as soon as they do have a change in circumstance, they need to report that. And let's say the change of circumstance happens sort of midway through, there would be a clawback. And so yes, they would have to report. Newcomers who have not filed taxes, can they create an account? Oh, I see. So there's 2 ways online. So there's the My CRA, which is not available to everybody. And we were just told by my colleague this morning, I have not personally tried it out, but they can also open a My Service Canada account, and there's an ability to essentially, there's a box that pops up and you can ask to essentially transfer or convert your My Service Canada account into a My CRA account, and that would be done even if you haven't filed taxes previously. That's my understanding. If all else fails technologically, or if they're barred because of a lack of CRA sign-in access, they can always call the number. But again, that should be a last resort if they have other ways, because it would be very backlogged, especially on April the 6th. Sorry, I'm seeing some statements and not necessarily questions. Part-time worker, youth 18, works for the city due to closure. Can they apply for CERB? Yes, they can apply for CERB because they're over 15, and sorry, the chat box function sort of switches every time there's a new comment, so I lose the question. So essentially, yes, if they lose their income because of COVID-19 and the city is closed because of that, the city park or what have you, then they are eligible to apply. Are folks with implied status eligible for CERB? Avvy, you might want to jump in on this if you have a different opinion, but
yeah, I would say the answer is yes. If they have implied status, and I assume that you're talking about people with work permit. Let's say their work permit had expired, they have applied to renew it. Then their work permit is still valid under the immigration law, so they should be able to, they should be qualified for CERB.
So if your work permit has expired and you're trying to reapply, then generally yes, if it's within the time frame as well, you're having that restored. To apply, sorry, for CERB, meeting the eligibility requirement is only for the first application or for each application. If someone starts work on April 2019, are they eligible for April? How about May? So if you apply the initial time, you have to meet the 2 weeks out of 4-week period and all the other eligibility requirements. Thereafter, you basically have to just keep attesting that you have not received any income. There's certain, it's not clear because it's not in the regs, but there's certain provincial supports that are allowed. It just depends on each province. It's unclear at this stage which provincial supports are allowed, where you can receive both those supports as well as CERB. But we know that if you're receiving EI, or you're receiving paid leave from your work, or you're receiving any other provincial supports in terms of pregnancy and maternity leave, well, as well as EI leave in those categories, then you're not eligible. And so if somebody, let's say, well before the COVID-19 pandemic, they were already receiving EI parental leave benefits, they would essentially have to wait out until those benefits have run out, and they can then apply for CERB if they're not able to return to the workplace. Now, if they finish up their parental leave and their workplace, it's, let's say, is essential service, and it's safe to work either in the office remotely, then they would have to talk to their employer about that, and they would not automatically be eligible for CERB. It's simply, it's a case-by-case situation. Let's see, sorry. Are there any other newcomers who have not filed taxes? I think I did that. Are there any other questions? If you have a question that I haven't answered, please put it in the chat box now. Sorry, it's just a little bit confusing. Just scroll up and down. Oh, so refugee appeal was rejected. Apply for HNC, can apply for OW. I'll give that one to Avvy.
Sorry, I didn't see that question. Can you repeat it?
Sure. Yeah, it's. I assume just reading into it. So if the refugee claim was rejected, I'm assuming they went all the way up to RAD and maybe even JR, and they applied for HNC now. Can they apply for OW?
Yes. And I see a couple of questions around the status issue. There's one that says the client has no status. And in financial hardship, what kind of benefits could that person apply? Again, I would suggest OW. There was a question about a client with 2 Canadian-born kids. She has no status, but her HNC is almost finalized. So I don't know what the question is about, if it's about CCB. Sorry, I'm getting an echo. It's very annoying. I have also seen cases where a client who, like we have represented client who applied for CCB and their HNC has been given approval in principle, that Revenue Canada has an internal policy to approve CCB in those cases. So even technically, under the law, they are not qualified, but Revenue Canada has, I have seen in those cases, provided client with CCB. So I would suggest that if the question is about CCB, I would suggest that person should apply for CCB. A refugee claimant who has a valid work permit but not SIN. SIN is not valid. I'm not sure what that means by SIN is not valid. So usually the refugee claimant will get a SIN that starts with number 9. If you have a work permit which is valid, you can continue to work and you use whatever SIN the SIN number that you have already applied for. I don't know if this question has been answered. Okay, I think this question.
I have a question about what happens if your income is only lowered, not eliminated, and let's say you work in Chinatown and your employer doesn't want to apply for any of the benefits that you do. I would suggest in that case they have a discussion with their employer to either participate in the emergency wage subsidy, wage assistance program that was announced yesterday, which is up to 75% of the payroll to a certain point, or the work sharing program that Avvy talked about. And this is because there's no other way under CERB because they have to have lost all of their income. And so they should have a discussion with their employer. Of course, it's up to the employer's discretion. The work sharing program involves mutual participation of the employer and at least 2 employees. And so there is some actions that need to be taken by the employee to essentially get the ball rolling. But at the end of the day, both the work sharing and the payroll subsidy require participation of the employer. If your income is under 5,000. There's one that says if I'm not eligible for EI or CERB because my income is under 5,000, am I eligible to apply for OW because this is my first year in Canada with a private sponsorship?
Yes. Yes. You can apply for OW.
Someone is saying if child is Canadian, parents are not documented, they can't get, I'm assuming they mean CCB, but it says financial help. Is that the case? That's the case currently, yes. Okay, looks like we are near the end, so I'll pass it over to Amy.
Avvy and Chien, thank you so much. And thank you to all our participants for sending in the questions. We will post the recording and the PowerPoint slides on our website tomorrow. Thanks, everyone. Stay safe.